Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Welcome back to Just Verdicts. Today, I'm joined by two rising stars in the world of medical malpractice in Western Pennsylvania, maybe the whole state. Ben Cohen and Carmen Nocera from the law firm of Harry Cohen and Associates. Carmen and Ben recently secured a significant verdict in a delayed diagnosis stroke case out in Washington County, PA. So in today's episode, we dive into strategy, the facts of the case, the peculiarities of it, the challenges, and the key moments that led to their success. So let's get started. Ben, Carmen, great to have you both on the show. Two young, rising superstars in the state of Pennsylvania and the world of medical negligence. Thanks for joining me on Just Verdicts today, guys.
Thanks for having us. We appreciate it.
Yeah,
appreciate you taking the time.
Anytime, man. I'm always excited to talk shop about great outcomes that hardworking trial lawyers got at trial, and that's exactly what you two did. So, as is the case, so often we'll hear about these verdicts that different lawyers and friends of ours get, and you see a little blurb on the listserv or in the news, but you never really know the details behind it. And we're going to talk about this Burrows v. Mon Valley Hospital case that the two of you tried. What was it, like a month or so ago?
Yeah, got the verdict in about a little over a month ago.
Okay, awesome. So why don't you, so Burrows v. Mon Valley out in Washington County. Why don't you two just tee it up for us? Explain, what are the basic facts of this case and some of the dynamics that led to it having to be tried to verdict.
So this case is about Steve Burrows, who is a 64-year-old gentleman, lives out kind of rural PA, and he was driving in his car one day, returning a work vehicle, when all of a sudden he gets just about every stroke symptom you can imagine. His body goes numb, he gets weakness, he experiences nausea, vomiting, calls 911, and EMS comes, picks him up, and takes him to the nearest stroke center, which happens to be Mon Valley Hospital. Despite Mr. Burrows experiencing just about every stroke symptom you can imagine, he was treated, he was, whether you want to call it an official diagnosis, but he was treated as if he had Bell's palsy. The ER doc was acting and treating him as if he had Bell's palsy and provided medication and treatment with that in mind. It wasn't until 19 hours after he presented to Mon Valley that he ultimately received the first, what we can call, stroke treatment, which is, at that time, he got aspirin. But with strokes, as most people know, the quicker you get to them, the better chance of a good outcome. And so time matters. And in this case, time went on and on and on before he got any treatment related to a stroke diagnosis. And ultimately, he was diagnosed with a stroke. And he, as a result of the delay in diagnosis, delay in treatment, he has permanent neurological deficits. And he's a tough guy. So he has worked very, very hard to get to a point that he actually is able to live independently. He has a friend that helps him out a good deal, but his life has been significantly impacted by this. And to get the full landscape of it, you have to understand who he was before. And before, he was this towering guy. He would ski, he did whitewater kayaking, camping, biking. He did the trail from Pittsburgh all the way to DC. I mean, this was an active guy. And he hasn't let this defeat him. So he has worked hard in a lot of physical therapy and gotten to a point that he can still live independently, but it is a much different life than what he had. He sleeps in a hospital bed. He walks with a significant limp. His vocal cord got paralyzed, so eating and drinking has become extremely difficult for him. He has to turn his head every time he takes a bite or sip of water. So it's a much different life than what he anticipated for himself at this stage. But credit to him. Everyone that knows him is proud of him. I know I'm proud of how far he's come, and he hasn't let this defeat him. But the treatment that he got was not sufficient, and it resulted in permanent damage. So that's kind of the landscape of what brought us to trial.
So I think it's always important to, or at least I try to imagine, what, in this case, the doctor or the hospital system or the people treating him, were thinking, from their perspective. And you mentioned, Bell's palsy. First, can one of you, talk a little bit about what Bell's palsy is and, why, because generally I feel like doctors they're not trying to hurt people. You know what I mean? It's, every once in a blue moon you hear about something insane, but for the most part, they're trying to help. Okay. But they can still make some very, terrible errors that can hurt people. What do you think was, where, what took this person down that path of Bell's palsy, which really isn't a very dangerous condition versus missing, these obvious signs of stroke as you described?
No, and I think that's an important thing to consider. Bell's palsy, you're correct, is not a dangerous diagnosis. But what it is essentially a facial paralysis. It's a temporary facial paralysis that mimics one stroke symptom. Oftentimes, people know with a stroke, you'll get facial paralysis in addition to other deficits. Now, with emergency physicians, they're always taught to do, a differential diagnosis and rule out the most severe and work their way down to the most benign. In this case, unfortunately, it was a younger physician who may have saw the facial paralysis and kind of pushed the facial palsy, Bell's palsy narrative. And the other part that I'm sure was led her to this diagnosis or to this treatment, with strokes, symptoms often wax and wane. So what can start as full left-sided paralysis, left-sided weakness, sometimes you can get a little bit of the function back, and it comes and goes without fully returning back to the baseline. And I think when the patient was in front of this doctor, while the facial palsy remained severe, some of the other symptoms may have not been as apparent. And for that reason, she did not do a thorough stroke assessment. While some of the nurses did and documented these stroke assessments, she did her own kind of cursory assessment of the patient, saw the facial palsy, saw maybe some of the functioning had returned, whether it be from his left-sided weakness or numbness, and moved forward with a benign condition, which is Bell's palsy. So, Carmen, I don't know if you want to add to that at all.
Yeah, I think too, Brendan, the type of stroke that he had a posterior circulation stroke, and some of his symptoms were alternating sides. And I think that is what threw this doctor off, is that that's not a typical presentation where the symptoms are going to alternate sides. With posterior circulation stroke, it is. So I think it's just an inexperienced doctor who didn't have a lot of exposure to a posterior circulation stroke and the signs and symptoms that follow with it.
Was that the, at least as far as, standard of care, arguing that she met the standard of care, was that the primary defense that you ran into from her and the experts that, look, this was an unusual presentation of stroke and it was very reasonable for her to, not have, recognized stroke and reasonable to believe and treat Bell's palsy in turn?
So there were a few defenses that we ran into. That was certainly one of them. This was a unusual presentation they referred to it as a rapid improvement of symptoms, which was contradicted by some of the nursing assessments done in real time. So there was the argument of a rapid improvement of symptoms and unusual presentation, but the larger defense that we faced was one that the patient had some, if you want to call them symptoms, the day before. With strokes, time of onset is imperative. When did the stroke symptoms begin? And doctors should be looking for an exact time and exactly what symptoms started at that time. With this patient, the day before, he had about a 15-20-minute bout of dizziness, and I think he threw up one time, one episode of nausea, and then he was fine. He got back to his baseline normal. They took that as a means to say his stroke started the day before, and therefore, even by the time he presented to the hospital, he was outside the window for any stroke treatment that could have made a difference. Importantly, with this time of onset, doctors, just about every physician, in this case, obviously we heard some conflicting testimony, but in real life, just about every doctor will tell you the time of onset is from the last time a patient was at his or her baseline normal. And with this patient, he had this bout of dizziness, nausea, and then returned to normal to the point that the next day he drove his car for over an hour. He had a stick shift, so it wasn't, he was moving his extremities fine. And then the sudden onset of symptoms, which the EMS documented as his time of onset, a nurse documented as his time of onset, and the only one who pushed his time of onset back to the day before was unfortunately the doctor who was guiding his treatment that day.
Did he mention the symptoms from the day before in that emergency visit, that he had the day before he had felt nauseous and thrown up and so forth and felt dizzy, or did that come up after the fact through like discovery and depositions?
So he brought it up. The EMS, he first brought it up to EMS because EMS documented in the record 20-minute episode of nausea and vomiting and then returned back to normal. This doctor documented that the patient had symptoms starting the day prior. And the important part here is she unfortunately heard that the symptoms started the day before and ended the inquiry there. What should have happened, and what doctors are trained to do, is say, okay, symptoms started the day before. Did you ever return back to normal? Did these symptoms ever stop? And if so, tell me when exactly they restarted, because this time of onset really guides treatment options. And with a stroke, one of the big medications or treatment options available is called TPA. It's a clot buster, and there's a specific window in which doctors are permitted to give this treatment, because at some point the risk-benefit analysis, it can ultimately do more damage if it's outside of this window. So the timing is so important to get exactly when a patient's symptoms start. If they resolve, if they do resolve, tell me exactly when they started up again. So there's contradicting, I don't know if you want to say contradicting notes in the record, because they all kind of fit into the same narrative that the symptoms started the day before, but some providers took that extra step to find out if those symptoms ever resolved. So while there is record. What was consistent throughout the record was that his symptoms started the day before. What was inconsistent was which providers looked further into if those symptoms resolved, and if so, when exactly they resolved.
Brendan, to your question too, the EMS did tell the emergency provider about the last known well time and about the episode from the day before and that it resolved. So she knew this information. She testified that she determines her last known well based on the start of symptoms, regardless of whether or not they even resolve. So she had no reason, according to the way she determines last known well, she had no reason to even ask the patient if the symptoms resolved according to the way that she determines it. So she never asked that question.
It strikes me that if that's their primary defense, which is obviously a causation defense, essentially like, hey, even if they messed up, it wouldn't have made any difference because his stroke started, long before. He was outside the window of any different treatment that would have made a difference, et cetera. But from the way that you looked at that, did that causation argument help you with the negligence decision? Because it seems to me what they're saying is they're essentially, giving up like, yeah, he had a stroke. He was having a stroke. We're sort of, well, she diagnosed it as Bell's palsy. So you kind of can't have it both ways. He can't have had a stroke that started the day before. And also it's okay that she completely misdiagnosed it as Bell's palsy during that period of time. I don't know. Did that become apparent? Did you argue that? Was it applicable?
Well, yeah, I think, frankly, it was. I think they may have lost some credibility in this respect because you can't argue that he wasn't having a stroke. We know after the fact, we know that he had a stroke. That was not in dispute. And even so, I think the defense took the position that it was reasonable for this doctor to treat or manage this patient's care as if he had Bell's palsy. So it was kind of saying, okay, it was reasonable to say he had Bell's palsy, but they were still considering a stroke. They just hadn't ruled it out yet. But the fact remained, no treatment was given that could have addressed a stroke. Now, obviously, TPA is the gold standard for the best chance at getting a stroke patient to a better outcome. But even if you're outside of that window for TPA, there's other medications to address that, whether it be aspirin, Plavix, Lipitor, that can prevent secondary strokes. And this patient's condition worsened from the time that he got to the hospital to the time he ultimately left. And imaging showed that additional strokes occurred later in the admission. So at a minimum, you want to get a patient some type of medication to prevent secondary strokes, none of which happened. So I think to your question, them arguing that it was reasonable to treat this patient and diagnose this patient with Bell's palsy while still in the back of your mind considering stroke, but not doing anything to address the stroke, I think that could have lost them some credibility, as opposed to saying, yeah, look, we know he had a stroke, but unfortunately, given the timing of everything, any treatment we gave wouldn't have made a difference in the end. So they made that argument, but still tried to make it reasonable that Bell's palsy was on the table.
They talked out of both sides of their mouth. I mean, on one hand, they say, hey, Bell's palsy is reasonable. On the other hand, the doctor is still saying the entire trial, well, hey, I'm still thinking stroke the whole time. I'm still working up for stroke. We're following a stroke protocol. I'm still thinking stroke the whole time. And we'll talk about it, I'm sure, a little later. But there's a phone call that just directly contradicts that position. So I think they lost a ton of credibility trying to make that argument.
Yeah, I think that's a great observation that you guys had, and especially at trial, when the jury's trying to figure out like who's kind of telling it to me straight. And I think they're always searching for like, okay, we know the plaintiffs, they're going to be biased one way, that these defense lawyers are going to be biased the other, but amongst them, there is some truth. And if you can kind of, subtly expose the fact that it can't be both, like they can't, like you said, they're talking out of both sides of their mouth. I think that's only going to help your cause so long as you guys can stay, credible in what you're forwarding as well. And I do want to get to that, and I want to get more into trial in a second. But one thing I'm curious about is, so sounds like so this ER provider concludes that he's having Bell's palsy. Obviously, we know that he was not. And at some later time, Ben, I think you said something like 19 hours later, they finally started to realize, hey, maybe this is something else. And eventually he was diagnosed with a stroke. What sort of changed the medical analysis of what is this guy actually suffering from?
Well, ultimately, he gets an MRI that is definitive. And an MRI is the best way to definitively diagnose a stroke. Now, MRIs aren't always the first line of defense in diagnosing a stroke. Oftentimes, you can diagnose it without the MRI, and frankly, you should, just given symptoms because of this timing issue. But ultimately, he gets admitted to the hospital, and the next day, he gets an MRI that shows infarcts and shows a stroke. And at that time, they said, yeah, maybe it's time to get him some aspirin.
Was this phone call, Carmen, you mentioned, happened during that period, or was it after even this MRI?
This was actually before he was admitted. This was while he was in the emergency department. And Mon Valley, they didn't have a stroke neurologist in-house at the time. So through MedCall, they would consult with a neurologist from UPMC. And that happened within, I don't know, Ben, within maybe an hour of him being, brought to the ER. And the only reason that the doctor calls the stroke neurologist is because our client had a friend who was with him who was calling the doctor saying, "You're wrong. He did not have Bell's palsy. You need to talk to someone that knows what they're doing. Talk to a neurologist." So the doctor then picks up the phone, calls the neurologist, and says, "Hey, I'm calling you because his friend is asking me to. I think it's Bell's palsy. I think he's fine. But let me just tell you what's going on." And then she proceeds to relay a fraction of the information to this neurologist. Doesn't tell him all the symptoms that Steve presented with. Doesn't tell him about the last known well time. Just says, hey, he had symptoms the day before, so, we can't do anything acutely anyway. But the phone call was just flew in the face of her position that I was thinking stroke still. We played the call. We showed the transcript. I mean, it was bad.
And that's great. So how did you find out about the phone call? Was that even referenced in the records, or did you learn about that in discovery?
So the emergency doc in her documentation says, I called the neurology services, and the way she wrote the note was, neurology agrees with me that this is most consistent with Bell's palsy, given, and she listed a couple reasons that were clearly not discussed during the phone call, but those were her reasons for believing that his symptoms were most consistent with Bell's palsy. So her documentation says, yeah, I called a neurologist. He agrees with me based on these factors. And then you listen to the call, and while he certainly didn't disagree with her, but he also, like Carmen said, had a fraction of the information that he should have in reaching a decision. And also importantly, at Mon Valley, at the hospital, they have access, as most emergency departments do, to video calls. And especially when you don't have an in-house neurologist on staff, it's important for a neurologist to lay eyes on a patient, especially when the emergency room doctor can't explain certain symptoms. And on this call, she flat out says, I think it's Bell's palsy, but this alternating symptoms doesn't make sense. And then she just leaves it at that. And that's exactly when you get a neurologist involved. Let the neurologist lay eyes on him. This is what they're trained to do, to pick up on subtleties that an emergency doctor might not be able to. And that never happened. Mr. Burrows, Steve, wasn't seen by a neurologist at any time until he ultimately gets diagnosed the next day.
Now, understanding it's always easy, for, lawyers to Monday morning quarterback, but out of curiosity, I sort of just put that out there before I ask you this question. Did you take the deposition of the consulted neurologist, to ask like, hey, if you had been told also, you were told A, B, and C, but if you were told also X, Y, and Z, would that have changed your take on things?
I did. And this was an interesting scenario, and maybe not unusual, in which both doctors, because of their employer, were represented by the same attorney. So, in speaking to and deposing the consulting neurologist, I gave him plenty of opportunities to say, if I had a little bit more information, I think I could have reached the ultimate diagnosis here. That wasn't what transpired. He was a bit of a team player and said, "Oh, even if I think the emergency doc gave me all the information that I needed, and even if she would have told me X, Y, and Z, I still would have reached the same conclusion because of the last known well time the day before. They kind of really had to dig their heels in on this last known well time and the stroke starting the prior day. So he went with that and said, even if I was told more information, I would have given the same recommendations. And importantly, what he did was he recommended aspirin, Plavix, and Lipitor, which is what the medications are to prevent secondary strokes, as I mentioned earlier. And even still, the emergency room doctor never ordered those. She didn't tell the admitting team to order them, so they weren't ordered until the next day.
So you have to wind up trying this case, as we often do. I mean, you obviously have some very good facts. You've got a good client. I mean, from your vantage point, and you can't know for certain, but why do you think the case had to be tried rather than, reaching a resolution beforehand? Like, where were the sticking points? Were they just so adamant that they were a lock on causation, or was it other factors?
Yeah, and Carmen, you can jump in your opinions. I think it's probably a few things, and I'm guessing, who knows what ultimately led it to trial. But I think first and foremost, they were very locked in on this causation defense, that even if they diagnose the stroke immediately, when he's in the emergency department, he's outside the window for TPA, and even whatever treatment they could have given, wouldn't have made a difference in the ultimate outcome. So I think that was certainly a big factor. And then there's always the issues of, you're in rural Pennsylvania. I think rural counties still have that reputation of being conservative, tough juries. So I think that played into it. And, who knows? Perhaps you got two young lawyers that, have to, that may have played a role, that there were much more experience, much more years of experience on the other end of the table than ours. So who knows? That could have played a role in it. So it's hard to say what exactly got it to trial, but I'm sure it was multifold.
Yeah, but I mean, I got to point out, I was reading something came across one of my social feeds that, you guys, young Pitt Law grads, and were you both Pitt Law 2019?
Yeah, this was a cool full circle moment for us. Carmen and I graduated law school together. We actually were on mock trial together, and he joined our firm, I don't know, about a year ago.
About a year ago, yeah.
Yeah, so this was the first time we got to try a real case together and not in front of mock trial judges. So it was exciting to be able to do that, and what a great outcome for the client and for us.
Yeah, and I think that's an awesome story. I mean, that that's got to be so cool to have gotten to try a real case after trying mock cases together. And I'm sure, all that kind of multifactorial reasons for why the case gets tried. And I'm sure you're right that, you guys are younger attorneys, and sometimes it's, you can't get no respect for a while, or you have to earn your stripes or whatever it is until people kind of recognize you as a known quantity. But sometimes I think this is a good example. You get to try a pretty good case because that was part of the thinking. Oh, that they've got the young guys on the case; they must not think it's very good or something. And then you have an opportunity to get a shot at a verdict in a good case, which a lot of people, a lot of young lawyers, don't get that chance you guys got, and you took advantage of it. So let's pivot into the trial. So you're going to trial, and I won't go into names, but I know the defense attorneys that you guys went up against, and I mean, that's a really formidable, very experienced group of defense lawyers that you guys had to lock horns with, which is very impressive in and of itself. But, tell us a little bit about, who was the judge and what the voir dire process was like leading up to the start of the trial.
Carmen, you want to take?
Yeah. So we were in front of Judge Lucas in Washington County. Fantastic trial judge. I can't say that enough.
Yeah, he is. I have a case, just real quick. I have an extremely complicated case in front of him right now, and he is so smart and so well prepared. It's really impressive, almost intimidating at times how well he knows our cases. But yeah, so I agree.
No, I'll add this anecdote. There were oftentimes we would be in front of him, whether it be motions or just sidebar, and we'd give our argument, and then he would cite to his own case law. He does his own research, so
yeah,
he's prepared, but you also have to be prepared in front of him. So,
indeed.
But it's a breath of fresh air being in front of him.
Yeah, for sure. And I would say he was a great judge, even if we had a different outcome. I mean, he made it that enjoyable. So did his staff. They were all great.
Yeah.
So
I'll add, I've taken defense verdicts in front of him too. So it goes both ways.
Right.
I love the voir dire process out in Washington County in his courtroom. It's wide open. I mean, I think we had a panel, Ben, of 80 to 100 people. It was all day. I mean, 9 a.m. until about 6, 7 o'clock at night. We went through about 60. I think we made it through 60 people, but it's wide open. They obviously start with the more general questions, and then they'll call them back individually, but we have free reign to ask what we want to ask, follow up on what we want to follow up on. So it was a great open forum, I think, that really helped us kind of weed out some biased jurors and kind of identify who we thought could be on our side. But it was a good group, smart jury, wide open voir dire, which was great.
Carmen, did they start with that pretty robust questionnaire, that they have the jurors fill out that really has, 50 different questions, a lot of them really great questions. And they started with that. They've got the questionnaires.
Started with that. And we got that information way ahead of time, too.
Oh, so nice. Like the day before or days before?
Like a week or 2?
I think weeks before.
Wow,
no, they did that was huge. Being able to have that much information going into voir dire. So that was big.
Yeah, that's totally unusual. And then, Carmen, you're describing this kind of wide open. Was there an aspect of it where, this 60 to 80 person veneer that you two can speak to that group generally, or is it, hey, respond to these questions and then bring them back individually, and then you can really ask them anything you want back there?
It was the latter, not the former.
Gotcha.
The judge asked the questions at the beginning, and then we got to speak to them directly when they were pulling them back one at a time.
And you could pretty much ask them whatever you want individually back there?
I mean, I think it was supposed to be limited to following up maybe on the questionnaire, but, I think we had free reign to kind of stray as far as we wanted while, staying within the bounds.
I think Carmen actually came up with a great list of questions, and he didn't ask each potential juror all of these questions. We would have been there for 2 weeks, but mix and match a little bit. And the majority of the questioning was follow up to the answers already provided. But Carmen came up with some really good questions to just get the jurors to start talking a little bit and get an idea of who they are, what they believe, outside of, because with these questionnaires, oftentimes the way they're worded, they don't know exactly what they're answering, and they think it might be, they're trying to give an answer that it doesn't. So if you just allow them an opportunity to speak a little bit, I think it was helpful for us to get a sense a little bit more of who they were. So credit to Carmen there.
Can you give me an example, Carmen, of some of the questions that you asked to get people talking or opening up a little bit further?
Yeah, I think and when Ben says I came up with the questions, Keith Mitnick came up with the questions.
Hey, we got to go to, we stand on the shoulders of giants, right, guys?
Right. And it's a lot of it was fleshing out bias. I also wanted to know if jurors were comfortable, because they're going to hear from two different sides. They're going to hear from two different groups of experts. And I gave some preamble. I think it went something like this. I said, look, you're going to hear from one group of experts, all Ivy League educated, all have big resumes. They're going to have one opinion. You're going to hear from another group of experts, same credentials, same qualifications. They're going to have a different opinion. So are you comfortable with sitting here for 2 weeks, listening to people who have far bigger resumes than any one of us, and they're going to disagree on medicine? Are you comfortable using your common sense to figure out who's shooting you straight? And what I wanted to do during voir dire, and what I think we did a nice job of, I relayed to every potential juror that I want them to use common sense, because the facts of this case, Brendan, if someone showed up to your house for a dinner party with all this guy's symptoms, you're diagnosing him with a stroke. You're not going to look at him and say Bell's palsy. So I wanted the jury to use common sense and how they sort of, the framework for this case. And a lot of questions were geared toward using common sense.
I think that is such an important question if you can ask it. Greg and I and Garrett weren't able to ask such a question in our last trial, but Mitnick talks about that. And, I recently interviewed Harry Plotkin, and he said that that's one of the most important questions to ask, because if there are people that wind up on there and they don't feel confident enough to say, well, who am I to decide between two, groups of opposing world-class experts? That's not good for the plaintiff. That's somebody that they're not going to move the ball. They're not going to make the decision in your favor. They've got to do something for us to win. So to identify those people who do feel comfortable, that have the confidence to be able to make that decision between these two competing versions of medical opinions I think it's a huge question to get out in every med mal case that we have. So you get your jury, it takes all day. And then do you guys open first thing the following day?
Yeah, we opened first thing the next day. There were 4 total openings. We opened first, and then there were 3 attorneys, one who represented the emergency room doctor and neurologist, the hospital, and then a radiologist. And so after openings, and I think I'm trying to remember if we got to a witness. I think we did get to the emergency room doctor in that afternoon. So the openings took the morning, and got started with witnesses that same day.
Well, walk us through how you approached your opening in this case. So you've got multiple parties that you've got to address. How did you open the opening? Like, did you use a rule or rules like reptile or edge type stuff? Did you do just something like a hook, a summary? Yeah. How did you, what was your flow of the opening?
So the way I tried to do it is right off the bat, I wanted to give them 1 or 2 sentences. Here's the case. It's a case about a failure to diagnose a stroke that resulted in permanent neurological damage. That I just wanted to let them know right off the bat, that's where this is going. And then from there, I got into, I wanted to talk about the theme a little bit. And so it wasn't necessarily a rule. It's a rule slash theme, I'll say. But I started with the notion that, with strokes, something that you'll hear in everyday life, whether you're going to the doctor for a broken leg or otherwise, you always see posters in the emergency room that says be fast, or time is brain. This concept that time matters is prevalent in everyday life. I think everyone can agree with that. So I wanted to get that out early, and I let them know, here is what you know. This is what you're taught in everyday life, and this is what just about every doctor would agree with, that when it comes to stroke diagnosis, time matters. And I used time is brain was kind of a theme, because that's an agreed upon concept in medicine. Time is brain. So I laid out, that's what we know, that's what doctors agree upon. And the only time you will hear that concept does not apply is by the defendants in this case. So I kind of laid that framework of, here's what the case is about. This is a generally accepted medical concept. However, for the next 2 weeks, you're going to hear from these folks why that coincidentally does not apply to this case. And then I went into the kind of the story starting from the beginning and working them through, what exactly happened. So that was a little bit of the framework. And then, I was I went a little, I think my opening was about 50 minutes total. I know there's some people like to be quick, get up and get out. Other people, want to make sure this is the first time you're heard by the jury, so you want to make sure you leave an impact. So yeah, I tried to. There was a lot of medicine, a lot of facts to get out, so I tried to do it efficiently. But what resonated with them, I don't know. But that was essentially where I wanted to take it.
Well, I mean, I'll tell you that as far as the timing and so forth, I mean, everybody's different, and it can work and not work no matter how long or short you do it. I remember, talking with Prokosky on his big verdict he got a couple years ago, and he said his opening was like 12 minutes long. And then I'd talk with Mike Calder, and he has, generally very longer openings, and I generally am somewhere in between, and you gave 50 and you guys want, you know what I mean? So I think the point is that as long as you're hitting the main concepts and getting those key issues out, and it's a compelling opening, there's no, set formula for it must be this long or short or so forth. So obviously you got things off on the right foot. So did you call one of your experts first?
We actually started by calling the defendant emergency room doctor.
Oh, I love it. Tell me about why you did that and how did it go?
We decided that we wanted to get the jury on our side quickly and right off the bat. And we felt that the care provided by this doctor just was bad enough, or that we could do that. And I crossed her to begin, and I didn't want to be too aggressive because I didn't want to just come out the gate flying, but I wanted the jury to know that this is going to be kind of the framework for what you're going to hear over the course of the next week and a half or so. And given her demeanor during her deposition, she wasn't a smooth talker that I thought, gave really good explanations for the care and, could talk her way out of some of these situations. So given her deposition testimony, some of the things she couldn't really run away from, and ultimately just her testimony, I felt that we could get the jury on our side quickly with her starting things off. So that's essentially where we landed.
Yeah, no, I mean, there's always that, do you call the key defense people in your case? I was on cross. Do you wait to cross them in their case? And again, I really, grown to learn. It really just depends on the circumstance of the case and what you think of them and what you can get from them and the impression they're likely to make. How did you feel that it went? I mean, did you feel that it went the way that you were sort of hoping it was? Were there any backfires? Were there any, opposite mic drop Perry Mason moments, or was it just more you kind of got across that overall impression that you thought you could?
Carmen might be able to talk about it better because when you're in it, it's hard to know what's landing or what's not. But I think it did go well in that I do think her testimony came off combative, and it wasn't there was no remorse, no maybe things could have went a little differently. It was the aggression was kind of on her side more than from me. While there were certainly times that there was a back and forth, I think she came off a little combative and may have turned off some jurors, but I don't know. What was your take, Carmen?
I thought it went well because she gave some really good admissions during her deposition that she couldn't stray away from at trial. She came across as inexperienced in the way she testified. She came across, I thought, as unlikable, disinterested, thought that it was beneath her to be there, that this is a waste of her time, of everyone's time. So I thought that she came across very unlikable. And I didn't think that there was anything that her testimony from her deposition was her testimony from her deposition. The records are the records, the facts are the facts. So there wasn't anything I thought that could have really backfired. Now, I say that knowing that anything could happen and anything can go wrong at any moment, but she was pretty locked in, and she was dug in too on causation. So I mean, she was ready to fight. Whereas if she just took the stand and said, "Look, we screwed up, but it didn't make a difference," I think she'd have had a lot more credibility. So I think that really set that kind of started them out behind the eight ball, I thought. So I did think it was very effective.
So walk me through did the trial really wind up taking 2 weeks? I mean, I know there was multiple parties and stuff, but it really did go that long?
It did. And that was the one, we would not have wanted it to take 2 weeks. I think with trials more than ever, and I think, Brendan, you're as good at this as anyone, moving efficiently through a trial, the speed trial. And we did our best to move things along, but the amount of experts, the amount of witnesses, the fact that there were 3 defense attorneys, it did take almost every bit of it. I mean, the first whole day was jury selection, and I think the jury went out the following Friday around 1:00. So it did take almost every bit of 2 weeks. And I think the jury was clocked out, frankly, by the latter end of the second week. So I would have liked for it to be shorter, but it did take that long.
Well, I mean, you got to cover your bases. You can't, try to, cut away at the expense of knocking out, critical testimony. So again, you got to do what it takes for that particular case. And, I personally, just for my own, cognitive stress levels and so forth, try to shrink cases down as fast as possible, but it's not always possible. So over the course of go ahead.
There were several times where we, it's hard to not ask the question, when you're faced with some testimony, and I think both of us would turn to each other and say, we should just let this go. But I'm just going to ask 1 or 2 questions, Yeah. I think that maybe that's our inexperience of not being able to just leave things go. So I don't think that extended it to the 2 weeks, but I know that was certainly difficult for us to leave things unanswered.
Over that 2 weeks, and I know what you mean, that by the end of it, it's like the jury's like, we've got it all, another witness, like we've already pretty much know what this is about and which way we're kind of leaning. But were there, in addition, it sounds like you got off to a great start with, trusting your intuition that the ER doctor was not going to come off very great. Doesn't sound like she did. Were there any other kind of, pivotal moments or turning moments you thought, whether it was in your case or their case?
You know what? I thought that, we talked about the conflicting records earlier, where some of the records talk about, Steve's symptoms started the day before, but doesn't mention resolution. Other records do show that, the providers asked the right question. So the defense attorneys, they decided to take those records entirely out of context during the cross-examination of our emergency medicine doctor and during their openings. So they showed every single record that didn't say that the symptoms resolved and tried to paint a picture that these symptoms were continuing from the day before. So I thought what worked was during the redirect of our emergency expert, I showed the corollary to every record that defense counsel showed. And it was a painstakingly slow process of putting up each other, because for every record that was good for them, there was another one that was bad that they didn't show. So during redirect, and we had an expert who was a very likable guy, I would show him the record and say, hey, Doc, it looks like counsel might have forgotten to show you this record. And the doctor picked up on, he's like, yeah, he must have forgot to show me that one too. And we kind of just went through record after record after record after record that they didn't show. And I do think that impacted their credibility at that moment very early in the trial. I thought it was hard for them to overcome that.
I think that's great. And I went to Mark Lanier's CLE he puts on every year, I don't know, maybe 4 or 5 years ago. And he said that, while direct is sort of like you have to get through it, whether it's with an expert or whatever witness, it's redirect where he is like ready to pounce and where he feels is the most, powerful point. Oftentimes in trial, it's like his favorite thing is redirect for that exact reason, because so often you're given those opportunities by people, that you can pounce on where you just literally couldn't do it in direct, but not until they set you up and provide you that opportunity to hurt their credibility do you now have that kind of beautiful moment. And I think going long there is great because it's that slow burn, you're just, really painstakingly showing like, come on, look at all this stuff. They just made this decision to hide from the jury. So I think that's super powerful.
Yeah, we even took a cue we took a cue during voir dire. One of the jurors in talking said, in talking about whether it could be fair and partial, he said, look, context matters. So, when I hear this information, I just got to be able to put it all into context. So we took that as a cue and made sure that throughout the trial, any record, any information, any testimony was always put into context and digestible for the jury.
Yeah. And that's, what a great, another, Mitnick-ism of putting things in context, which, we read all these different books and you kind of have to figure out like, what do you like best in using? Personally, I love, in opening, for example, but then using as a theme, Ben, like you're talking about that concept. Well, let's put that in context. And yeah, embracing that just throughout trial because it does exactly what Carmen's talking about. It sort of shows like you are the reasonable ones. You are the people that are going to show you everything so they can put it in context as a part, opposed from the defense who's cherry picking or just trying to pull the stuff that's helpful to them and maybe, pull the wool over the jury's eyes. So 2 weeks, guys were probably pretty beat up and tired by the end. That's why maybe it's a somewhat young man's game or young woman's game these days. But so you go into closing. Tell me about closing. How did you approach that? How did you feel it went by that point in time?
I was gassed, so I let Carmen handle the close. So I'll let him talk about it.
Yeah. So, with regard to the closing, I'm not someone that wants to chase down everything that defense counsel says before I get up there. And during trial, I don't want to have to chase down everything that they say. But the closing was about credibility, context, and common sense. I mean, that's kind of the framework that I delivered the closing through. I, called out anything that the defense attorneys took out of context. I highlighted that. But with regard to how I structured the closing, I mean, I think I started immediately by showing the jury the jury instructions on increased risk of harm, because during defense counsel's closing, they decided to read just the causation charge out of context that's not helpful to us. So the first thing I did, I had the jury instructions in my hand. I said, guys, I'm not going to chase down everything that they just said, but I can't help myself. I got to talk about this. So the judge gave all of us these same jury instructions just this morning before we talked to you. I want to read you what counsel didn't read to you, because I think it's important for you to listen to this closing in that kind of framework of increased risk. So I read it to them, and then I got into, highlighting all the things that, all the big picture stuff. But what I thought worked, Brendan, was I remembered several conversations that I had with jurors during voir dire. One of them was the guy talking about context. And based on his questionnaire, he's a juror you would never want on your case. But he said, during voir dire, hey, I need things put into context. So during closing, I spent a lot of time talking about context, and I looked directly at him and talked to him about it. And I said, look, I remember talking to you about context, and you said you needed it because you could reach the wrong conclusion. And, so a lot of time was spent on context, credibility, and common sense. The defense attorneys decided to make the case about our credibility as plaintiffs' lawyers and all the biases and stereotypes that come with it. So I addressed that in my closing, and I told the jury, hey, there's a reason they spent so much time talking to you about, money damages and people who file these lawsuits. There's a reason for it, because they know that people have a bias. That's why we spent hours talking to you about bias during voir dire, because we know that it can blind a jury. And you promised us it wouldn't, So I was able to spend a lot of time talking about those things. I could have gone up there for like 4 hours. I mean, there was so much to get into. But I cut it out at like an hour. And, what was cool, I got to, we grow up watching, all these big trials on TV, and everyone wants their Johnny Cochran moment. And, that phone call I thought was so important, because it just went to the credibility of the defendant. She's saying that she's thinking stroke the whole time, but the call says otherwise. So I spent a lot of time telling the jury, guys, the call says it all. The call says it all.
That's great.
And, as I'm talking about the call, Diadogo's pulling up the transcript behind me, so it's really seamless so the jury can see it. And, it was fun to get up there and give that closing. I told Ben before closing, if the jury can both laugh and cry during this closing, I'll feel good about it.
Yeah.
And that ended up not on purpose. It just happened. But, now look, everything, you feel like everything goes well when you get a verdict. So
right. Yeah.
I could try the same thing next
time. When the jury went out, we were hardly thinking, oh, this is in the bag. It could have went either way, like all of these cases. Looking back, obviously it's easy to say, here's where we think things went right or maybe went wrong. But we've all been a part of enough cases that went the other way where we think, oh, everything went in great. So it's so hard to know what exactly landed. But no, I think Carmen delivered a great close, and the case went in well. So we were happy with it.
No, and I'll tell you, you mentioned Diadogo, who's your trial operator and who's been mine many, many times and was our operator in the most recent case. And, guy's seen a gazillion different trials, and he was telling me about your case. And, I think the best compliment that you can take is from his observation that, you guys really threaded, you had a real needle to thread with the different, dynamics of this case, some of which we didn't get into, of what you were dealing with in that trial to still, come out victorious. I don't think that we can ever really fully do it justice, the number of obstacles, both factually in the case, but then external issues, that you guys, somehow got through for your client. So it's a real compliment to the both of you. So deliberations, was it a long one, short one?
It was long. It lasted 7 hours.
Oof,
And
ouch.
it was on a Friday, and I think they went out around 1 o'clock, maybe around 5:30 or so. The judge came out and said, "Look, they're still going. I'm going to tell them they can either come back on Monday, or we'll bring in some dinner for them, and we'll just keep going." And the jurors opted to get some dinner, and wrote it out. And so I think the verdict came in around 7:15, 7:30. So it
Were there
was
any questions?
there were. The jury wanted a lot of information. They wanted records. They wanted some of the agreements that came out, like employment agreements and things of that nature. And they wanted the transcript of the call. So they wanted a lot. They wanted some of the jury instructions. The judge ultimately sent them back with the transcript and some of the jury instructions on negligence and causation. And then, so when they went back with that, they deliberated for a while, and at some point came back with the question, was the emergency department doctor acting as an employee of the hospital? So they were essentially asking about agency without, asking about it, because I think they wanted to be explained what that meant. But that was the main question. So we were optimistic when that question came in that, we didn't think they'd be asking that if they weren't looking to find somebody responsible. But then they continued to deliberate for another, I think, 3.5, 4 hours after that. So, that was kept us guessing.
And I don't know if you guys are gluttons for pain, but waiting on a verdict is just my absolute least favorite part of the entire process. It's just sickening. It's out of your control. And some people seem to have like this Zen takeaway, like, oh, there's nothing more I can do. And I try to do that and I just can't. It's just the worst. It's excruciating and I just hate it. I don't even like thinking about it. I get PTSD thinking about those deliberations.
Oh yeah.
So
it was long.
So tell us how did tell us what the verdict was and how it broke down. And actually, before you get to that, I didn't ask, were there economics in the case? Was there any earnings or a life care plan or anything like that involved?
So there was. We didn't end up posting any of the economic damages. He did work, and we ultimately decided to not bring that into the trial. He was 64, so there were economic damages, and the fact that he was living independently, bringing a life care plan might not have been as impactful as we would have wanted it to be. So ultimately, we went all non-economic damages. The jury came back with a verdict of $856,000 against the hospital and emergency room doctor. It was 236 to pass, 620 to feature.
Do you have any reason why that happened? What was that about?
No, we were able to talk to the jury after, and we were thinking the same thing. So where does this come from? And ultimately, it appears that it came from something like an average. They polled everyone, and where they thought maybe they kind of averaged out everybody's.
Okay. Right. Okay. Yeah. I've seen that a lot. Everybody writes their numbers down, they add them up and average them out, and then everybody can kind of live with that. So they're trying to be reasonable and practical. I mean, people can disagree whether that's a fair approach or not, but who are we to say that's not a reasonable way to go about it?
Right. And I should add that part of the verdict also, there was a radiologist whose care was at issue, and their defense was that even if they got the imaging read correctly, their they wouldn't have done anything differently because of this causation issue. So the jury actually found negligence on behalf of the radiologist, but no causation. So the verdict was entirely on the hospital and emergency room doctor.
More threading the needle, so to speak.
Sure.
Well, guys, that's an awesome outcome. Can I give you one suggestion, you young studs, for the future?
Please.
All right. So I always, and mostly I always lost when I first started trying cases, but even when I first started, when I won a few, I would always go and talk to the jury. Okay. And my suggestion, I heard this maybe from Ed Saramboli or anybody else, and it makes a lot of sense. Go and talk to them when you lose. Do not talk to them when you win. And the reason being, if you go and talk with them when they win and somebody tells you something that was completely out of, like that shouldn't have happened or something that happened, now you've got to go and tell people, and you could inadvertently screw yourself on your verdict. Versus the other way, if you lost and you hear about such a thing, well, maybe you get a second bite of the apple. So I always wanted to know what people thought. And of course, I'm a total narcissist, so I wanted them to tell me how great I am. But that's just my 2 cents. Take it or leave it. But you guys don't need advice from me, given how well you're doing. And
no, we'll take it from you. I mean, congratulations are in order to you as well with the verdict you got recently. And I'm looking forward to listening to the podcast where you tell us how it's really done.
Yeah, sure. We thank you for that. And that was all worked up by Greg, and tried it with Garrett. And it was a super fun group experience. And I'm sure you two can attest that you got to try these cases as a team, trying to do that solo, both from energy, mental ability, just the insights that you two share, on, well, I think this, I think that, and then you kind of meld the best case together. The fact that you guys were able to do, Ben does opening, Carmen, you do closing, I think just speaks to, when you find that good, teammate or group that you can work together, I think that's by far the best way to try these cases. So again, guys, congratulations to both of you. I was super pumped to hear about it, see it, and now get to talk to you and learn more of the details in it. I'm sure I'll have you both back in the not too distant future to talk about more verdicts. But in the meantime, enjoy this one. It's great at this point in your careers to have already knocked out a med mal verdict. And I will also say, and this is, maybe this will cause a fight with people, getting a verdict in a medical negligence case against an individual doctor, and I think Mitnick's even said this, that's the hardest verdict to get. I don't care. Any other case, you put it up against getting a jury to hold a doctor responsible, no matter how good your facts are. That is the toughest case. Okay. And I think just again speaks to your guys' trial skills and preparation, the workup that you did that brought that about. So congrats, guys. Look forward to seeing you in person one of these days. And thanks for doing the pod. And until next time, I'll talk to you soon. Okay.
Thanks for having us. We appreciate it.
So I hope you enjoyed that incredible breakdown from Ben and Carmen on their heart-fought stroke malpractice case out in Washington, PA. I certainly learned a lot from it. Again, always that recurring theme of credibility, maintaining yours, hopefully putting dents in the opposition, the unique ways that every solid, successful medical negligence trial lawyer approaches trial is always eye-opening and helpful to see. So thanks again for listening to Just Verdicts. Stay tuned for more deep dives into cases that shape our practice in the future. And again, if you wouldn't mind, please leave a review if you haven't before. And if you like any of these episodes, you're getting some value out of it, please consider sharing it with a friend. As the more people that listen, the more we get the word out, and the better able I am to continue publishing these Just Verdict podcasts, which I enjoy so much. So until next time, I'm Brendan Lupetin. This is Just Verdicts.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.